dia a todos e a todas.
Good morning, everyone. My name is Marina Sanchez Wunsch. I'll be the mediator of this morning's panel of the last day of the seminar, International Seminar of ULMA, Center for Human Rights and Corporations. I'm a professor of human rights and international law of Unipampa in Rio Grande do Sul in the south of Brazil, and I'm also an associate researcher of ULMA. I work specifically in the agenda of International Agenda for Human Rights and Corporation. So firstly, I'd like to thank everyone here for their participation, particularly our speakers, our guests. We have the honor to be able to listen to today. We have Juliette Renaud from Friends of the Earth, France, Victoria Laurentiis of the Business and Human Rights Center of the University of São Paulo, Yvette Gonzalez of the Poder Project in Mexico, and Professor Eduardo Sanchez of the Business and Human Rights Center of the University of São Paulo, USP. Our theme this morning is due diligence laws and national action plans, critical perspectives. So the objective today is to discuss the initiatives of national action plans that exist and those that are under construction, as well as due diligence laws based on a critical perspective focused on effectiveness and context. So you can observe our speakers will speak about these initiatives from various perspectives. Juliette will talk about the due diligence law in France. Yvette about Mexico. Victoria and Saad will speak more about Brazil. And so I think it'll be very rich for us to discuss both due diligence laws and national action plans. So just to situate the debate, the national action plans correspond to the regulatory drive, the voluntary regulatory drive to implement the guidelines for corporations of the UN. And these have been formulated since 2012. The first ones were published in 2013 and with reference to the Human Rights Council's guidelines. And more specifically in Latin America, they started to be implemented about 2015 on, and the aim of the plan is to incorporate the guidelines As for the due diligence laws, we have to understand the concept. It's a concept that involves a range of processes with a view to identifying what they call adverse impacts. We use the term that it would be more correct, which is human rights violations, to prevent and mitigate these human rights violations, monitor implementation of results, and the company would have this obligation to communicate the impacts and monitor itself and its supply chain. So recently what we've observed is the introduction in the domestic legislation of due diligence practice vis-a-vis human rights. So there's a dynamic which is growing among governments to demand that companies carry out this due diligence compulsorily, and the French law was one of the first items of legislation to deal with this specifically. So this will be one of the aspects we will talk about today in the panel. So we notice that both these instruments present themselves with the intent of building a paradigm which is voluntary, of self-monitoring that comes with the guiding principles of non-establishment of direct obligations for human rights, and much more perspective of prevention. And furthermore, another question that emerges is to what extent these instruments can be a counterposition to the binding treaty on human rights and corporations. So this discussion, and to try to understand a little better the direction things are going with national plans and due diligence laws, that's why we're holding this panel today. So we're very much excited, thrilled with this event. So I hand over without further ado to our speakers, who will have 15 minutes each for their talks. And of course, at the end, we'll have a moment to share, to discuss, Q&A, etc. To discuss whatever aspects people would like to. So if you want to put a question to our speakers, put them in the Q&A or the chat function and tell them who you would like to answer. Okay? I remind us all that we have simultaneous translation, so you can choose your language. There's a little globe on your computer screen or on the 3 dots that says more if you're on a phone. You can choose interpretation and then click on your preferred language. Okay. So now I hand over to our panelists, beginning with Juliette Renaud from Friends of the Earth France. She is responsible for the campaign about transnational regulation. Since 2008, she has worked with communities affected by mining and oil companies in various countries, particularly Argentina, where she lived for various years and worked as an assistant to, an advisor to Nobel Peace Prize winner Adolfo Pérez Esquivel. At Friends of the Earth France, she's responsible for the political defense and for the activities of the public campaign related to the impunity of transnational corporations in the field of human rights and the environment. As such, she has been part of a range of organizations that have fought for the approval of the French law about the due diligence. Juliette is also coordinator of the French coalition for the binding treaty of the UN. She has a master's in economics and development from Sciences Po Paris. So it is with great pleasure that I hand over to Juliette. Thank you. I'm going to speak Spanish, but my presentation is in English. I'm going to share my screen now. Hopefully it works. Okay, great. So the idea in these 15 minutes is to present to you the pros and cons of this law. We don't call it due diligence. We call it the duty of vigilance. I'm going to explain. So I'm not going to talk about the European directive, but if that is being hashed out, but if anyone's interested, they can ask. So the French law was adopted in 2017, so a little over 4 years ago. It was inserted in the French trade department. So these are companies that have more than 5,000 employees and that are registered in France. So that's the first weakness. So companies that are very big, you have to have more than 5,000 employees in France or 10,000 worldwide. So for example, oil company Perenco that is has fewer than the threshold, and they don't have to comply. What it does include, it's companies registered in France. So a company like Amazon, it's an American company, but its subsidiary France has more than 5,000 employees in France. So it has to comply with the law. And the strength of the French law is that it applies to the whole of the supply chain and the economic group. So the activities of the company, but also covers the suppliers and subsidiaries and controlled companies, and also subcontractors as well. So this term of consolidated commercial, which is consolidated in French law, a commercial relationship, a consolidated commercial relationship. It's the first law, therefore, that starts to unveil the issue of the direct accountability of the mother company over its subsidiaries, its suppliers, subcontractors, etc., the whole value chain. And also another point which is important and positive point of the French law is that it covers all the economic sectors, unlike other laws about extractive industries or deforestation. So it covers, it also has a very broad definition of violations. So human rights and fundamental freedoms, health and safety, and the environment. So this goes for both sectorally and in terms of what constitutes a violation. That's a positive point of the law. So more concretely, what are the obligations? So a threefold duty of vigilance. The obligation to establish what we call a vigilance plan, a plan of vigilance that describes the processes. This is the part that is linked to due diligence, describes all the processes. So those are the components there on the right: risk mapping, procedures to assess the situation, including subsidiaries, subcontractors, suppliers, etc. Appropriate actions to mitigate risks and prevent serious violations. And where it goes beyond due diligence, it has to contain a whistleblowing mechanism, both for people who are inside the corporation that want to denounce some violations, and also in the communities affected. And the last thing is that there's an obligation to monitor and assess the effectiveness of the actions taken. The other thing is that the plan has to be established, but it has to be published as well. This is important in the sense that the plan in itself contains proof of what the company does or does not do. And this can be used later in a judicial context. And the way it goes further than due diligence is that there's an obligation of implementation. There was a whole struggle that must have effective implementation to insert that expression into the draft bill. So the other point, which is very important, that goes beyond due diligence, is that due diligence, it's about creating processes, but the French law says that there are elements of access to justice for the people affected and the accountability of the companies in general. So who can go to justice? So to the justice system. The affected parties, but also organizations that have the right to act, as we say in France. So organizations like our own, or human rights, or environment, and also unions, organizations representing workers, the environment, or communities. And there are two mechanisms, two judicial mechanisms. The first one that can be used before a violation takes place. So we can say a company, an oil company, is building an an oil pipeline and is not taking the sufficient measures to prevent accidents, for example. So we can go to the court and say this company is violating its vigilance duty because it's not doing everything it has to do to avoid environmental violations. So we're going to use the information published in the vigilance plan as an evidence. And there are two things that come about. So the plan itself maybe is very bad or doesn't exist. And that's the first thing, is a bad plan or a plan that on paper looks very good, but we have to demonstrate that in actual fact, in reality, is not respecting the obligation of effective implementation. The second mechanism, what we can do is an order from a judge to the company to do something, to improve its plan or to implement the measures, effective measures on the ground, and we can make very concrete demands uh, for a judge's orders. The second possibility is once a violation has taken place, then there is a suit to obtain remedies, compensation for the affected party or persons. So if the company is found guilty of violating rights and having harmed the environment, and then the compensation payments can be very, very high. It's a civil responsibility, something we didn't, one fight that we didn't win was that there was no criminal responsibility for corporations with this law. And the other thing that we lost was that the onus of proof remains on the demanding parties, on the people suing, in other words, the social organizations, the unions, or the citizens organizations, and the onus of proof is a very important thing. So, for example, we have to prove that there was a violation, that there was damage, that they violated the duty of vigilance, and the causality link between the two things. So this is sometimes tough in a court of law. How much time do I still have? Tell me if I have to conclude, okay? I want to show you the case that the first suit against Total for its activities in Uganda. They have an oil extraction and a oil pipeline. Environmentally, both the extraction is done in the middle of a protected zone, and the pipeline also goes through various fragile ecosystems. And socially, even before production started, they are bringing about the expropriation of more than 100,000 people, the eviction of more than 100,000 people. And so people had to give over their lands and to sign over the land, and they lost the right to use the land even before they received the compensation. So to go back to the central elements of the French elements, we are attacking Total, the headquarters in France, but actually about the activities of two of its subsidiaries and various subcontractors, which are the ones that implement the project on the ground in Uganda and Tanzania. We are working with various other organizations from Uganda and France. This started in 2019. It's interesting. This is the first case We are at the present in the summary proceedings. We're haggling over what is the correct court. Total wants to go to a commercial court. So on the 15th December, the Supreme Court will decide on the jurisdiction, which is the correct court. But in October, we won a battle in Parliament because the law changed. And so for the new cases, it's been clarified that all the cases of this law of duty of vigilance will be judged by the civil court in Paris. What we criticized in this suit was that both the content and the implementation of the vigilance plan of Total are not good. So there are violations that are taking place right now and others that are coming. And so the concrete challenges that we see, basically the onus of proof in countries like Uganda and Tanzania, there are many threats to the communities affected, the local organizations that are gathering testimonies, witness statements, and evidence for the case. It's very early days, so there's not been a decision yet, even as to the content of the course. We're still in the procedural affairs, which is the correct court. But the first debates we've already had with Total in writing and the first hearing in court, we see a weakness of the court, of the law, is that many of the debates focus on the vigilance plan, what a plan should be about and what it should contain, etc., etc. So we are debating uh, the standards that the company has to adhere to, and we are getting away from the debate of what the actual violations that are taking place in Uganda. Just to give you an example, a very worrying example, a decision of the appellate court about the jurisdiction, we are asking a decision on merit about the emergency that is going on in Uganda. People are going hungry because they can't use their foods and they haven't received the compensation yet. And there was no and the court said that, oh, there's no emergency because Total has published a new vigilance plan. So anyway, all this court proceedings, this haggling takes over a lot of time. So it's been 2 years. There's been no decision on the merit of the case, and people, are suffering. So a challenge going forward is if we obtain a favorable decision and the judge tells Total to take concrete measures, there'll be the challenge of how we're going to make Total actually do in another country and respect the judicial decision. Okay, that's it from me. Thank you very much. Thank you, Juliette. That was very informative. You brought us lots of interesting information about the French law, many provocations, so to speak. I'd like to start the debate right now, but we're going to leave the questions for the end and debate for the end. And now I would like to hand over to our next speaker, who is Victoria Laurentiis.
Victoria Laurentiis is a doctorate student in criminal law from the School of Law of University of São Paulo in the area of compliance and human rights and corporate responsibility. She's co-organizer of USP, Human Rights and Businesses Working Group, co-organizers of the book Corruption, Human Rights in Companies, published by the Plus 2 Publishing House in 2018, visiting researcher in the university in University of Yale in 2018, member of Yale USP Law Clinic, responsible for the guidelines of private sector and collaborative governance, worked as research assistant in University of Montreal, Canada, in the project Anti-Money Laundering Law, Brazil and Canada. received a scholarship for University of Freiburg in the winter course, graduated from the law school in Federal University of Ribeirão do Ouro Preto. I want to thank Professor Manuela and Felipe Boma for the invitation. I want to greet the other speakers and Marina, who is moderating this event. It's always a pleasure to participate in events that you organize, and it's an honor to participate in this panel with such renowned professionals dealing with a theme that is specifically relevant, the laws of due diligence, the national action plans. The proposed topic, the Brazilian initiative on the national action plan, deserves a critical vision on how we have built our Brazilian agenda on the topic of companies and human rights. In this topic, I'm going to base my talk in elements that need to be resignified and to undergo a critical assessment. Before entering the topic of action plans, we need to think on the statement that based on a holistic assessment, there isn't in Brazil any type of systematic and organized treatment for the relationship between companies and human rights, in spite of mechanisms of civil accountability, administrative accountability, or even criminal punishment. In Brazil, in the last Universal Periodic Vision of 2017, received 3 recommendations from the Netherlands, Paraguay, and Sierra Leone to create a national action plan on companies and human rights. And as a working group, we had the opportunity to participate of the public hearing in the House of Representatives to evaluate its implementation and to create a critical vision on this hearing. After this last hearing, it was clear that the committee that is responsible for creating the Brazilian action plan should develop a dialogue between different ministries, the Ministry of the Economy, of Mines and Energy, of the Environment, and several government agencies. And the idea would be to follow a certain steps with the goal of creating by decree our national action plan, the decree 5978 of 2008. One of the elements is the need of an international treaty of corporations and human rights. And this is not, it's a contradiction because several countries have developed their due diligence law and without the need of an international treaty. So since 2014, this intergovernmental group was formed to create an international binding treaty that would then enforce the accountability of companies for violation of human rights. So the construction of our national action plan has a lot to learn with the experience of other national action plans, especially this year, with the approval of the law of due diligence in Germany, and also the directive of accountability of productive chains published by the European Union, an obstacle that all countries have to face is a more detailed study of the rugged principles that exist since 2011 allow us to see that we have not advanced enough in the establishment, in the construction of an international juridical framework with clear rules for transnational companies in terms of the compliance with human rights. Hence, the need to build a national action plan as part of the implementation of the guiding principles. According to our working group, we need to have a key element in the connection with the guiding principles under 4 pillars. First, the specific context of each state, providing transparency and dialogue, and also reviews and periodic updates, always responding to the need of creating of a dynamic reality in each country. The reality in Brazil shows that we are significantly behind in this process, be it from the juridical point of view and the regulatory point of view. The normatives that have been created under this agenda also deserve a more careful review. When we think of the way that the guiding principles were incorporated in this so-called national guidelines, we can see several gaps. The document in itself was already based on a democratic deficit. There was no dialogue, there was no public hearing. Very sensitive topics were ignored that could be better developed, such as the notion of corporate complicity, due diligence, as an instrument of surveillance of human rights. And the point of attention is that these gaps have been repeated in the construction of what this national plan may become in Brazil. So there is no clear process at this point to establish the stakeholders, the role of affected communities, the role of civil society, for example, in the construction of our national action plan. So at the same time, there's a risk that must be outlined is this trend of using a very empty and inaccurate language when we talk of human rights. And exactly because we need this to become an obligation for companies, that's exactly why we need a lot of clarity and accuracy in this language. The collateral effect is a great difficulty to enforce the adherence on the part of companies or generate mutual understandings on that guidelines. So to talk about human rights in a certain sense, it's talking about a complex field full of disputes, narratives, normatives, but this in itself cannot become an obstacle to the enforcement of companies' obligations. This difficulty to translate a content, to translate a compliance with human rights into a negative or positive obligation on corporate subjects must be overcome. The possibility, for example, of advancing with the criminal law, with the criminal accountability of companies that today is limited in Brazil to environmental crimes, depends on a clear definition of what we understand by severe violations of human rights that can lead to a more severe intervention of the criminal law. Although we know that there is an international trend in the sense of recognizing this accountability, this corporate criminal accountability, there is still a strong debate on the model of attribution of responsibility, the way in which the judiciary branch should assess the criminal behavior by companies. And when we make a comparison, little has been done in Europe to establish the sanctions in cases of non-compliance, and this is also due to the obstacles and difficulties that we have in the creation, in the creation of legislations in these countries. But observing our reality, we need more than ever to provide like a normative density to these laws on human rights, especially in these last years where we have seen an increased risk of human rights violations due to corporate actions, the absence of organized national groups to investigate the team. And in Brazil, on the other hand, the need to interfere by the criminal courts. And it's necessary because it's a mechanism, it's formal social control mechanisms. It's a tool that can provide victims a direct form of reparation and indemnity for the recent corporate tragedies that we have witnessed. This conclusion is even clearer when we realize that violations in different fields of corporate actions, they do not come from an absence of developed model of corporate compliance. In most of the cases, they are a consequence of the business model, of business as usual. So for this reason, due diligence in human rights alone cannot undertake a meaningful transformation in the corporate culture if it's not accepted as a tool, as an instrument for addressing these violations in the corporate world. Bringing a more critical perspective, the National Action Plan should also become tools and instruments to map out this field and allow the assessment of challenges in terms of human rights compliance. And in this fact, I advocate for the fact that we are lagging behind. The creation of an effective national action plan depends on mapping out data, the obstacles, the challenges that we have to face. And this is based on another premise, which is the assessment evidence-based policies. We had the opportunity to conclude in our public hearing that we don't have a transparency mapping on corporate practices, measurement of damages, level of victimization in Brazil, and this impacts our commitment to corporate accountability, which is still very insufficient because we cannot even understand the complexity of the damages caused by corporate actions. We don't have initiatives that promote proper rendering of accounts on the side of companies. In this area of ESD, we are still lagging behind in terms of the real meaning of what companies could contribute to practices that would then respect and promote human rights. So we need to find pathways to encourage evidence-based public policies. We need to create the creation of the due diligence law in Germany, although it was certainly moderated. Initially, the text was more incisive, was based on a very broad national assessment organized, including processes of monitoring, guided by the Interministerial Commission of Human Rights in Companies. The problem of the absence of these players in Brazil leads to this difficulty of monitoring. It's difficult to think of clear goals if we are not using a real context on the levels of damages and victimization. So this process has its own contradictions. For example, the companies that are involved in the development and approval of laws of due diligence, these are companies where the headquarters are located, but we know that most severe violations of human rights are in the basis of their productive chains. In Brazil, we don't have any law that provides for due diligence in the productive chains. So in addition to this lack of enforceability, we have also the absence of a legislation to rule the relationship of headquarters with subcontractors, suppliers, all the links of the productive chains in the case of human rights violations. This is very clear when we think of some corporate scandals in the Brazilian reality. The most mentioned case in terms of severe violations of human rights, at least in the textile sectors, the Henneplack case involving the textile sector in Bangladesh. Cake was the largest German retailer with more than 3,000 stores in Europe. They were the main buyers for the Hana Plaza garment businesses. When they transposed this reality to the Brazilian scenario, if it had happened in Brazil, hardly would we have any accountability because we do not create this causal link, this accountability is relationship between headquarters, subcontractors, suppliers, outsourced companies, and this is not exclusive to Brazil. Even this very recent law in Germany on due diligence does not explore all the links of the productive chains. So we have an urgent need of thinking of a law on productive chains in Brazil, but it doesn't seem to be ideal that each company will develop their own legislation on productive chain without any collaboration will work. We're talking of companies that are located in much more than two jurisdictions. So it will be very complex that each country will determine different standards for the definition of productive chain. And we don't need even to think of international scandals. Even in the national territory in Brazil, the obstacles for accountability in the case of violations of human rights, Samarco and Brumadinho, these are environment scandals in our recent history. We have several actions, the several procedures that have not advanced because they are still interrupted by debates on the due competences, if this is the duty of federal courts or local courts. So we still have many obstacles to litigate against corporate players. So I close my speech saying that the strategy of national action plans represents, yes, an advancement to the development of the normative framework. We can prov point out to the liability of different corporations, but we have challenges to beat this agenda in a democratic, transparent and participative approach, engaging different actors. But it's an ambitious process, but very much necessary for us to better address the need to create this legislation and also to reform our regulatory policies. Thank you. Thank you, Victoria. Excellent talk. I'm going to pass the floor to our next speaker, and I want to remind you that if you want to, you can ask your questions in the chat box. Our next speaker is Yvette Gonzalez. She's senior associate in a power articulation project of a research and actions. Poder, it's a civil society organization, a non-for-profit social society organization that aims at providing transparency in Latin American corporations from the point of view of human rights and strengthening of civil society players affected by corporate practices. She's specialist in the topics of businesses and human rights and co-coordinated the focus group on civil societies, businesses and human rights in Mexico from 2015 to 2020. This group influences the creation of public policies, develops training of different actors, and actively cooperates to different national and international networks on the matter. Currently, the group is promoting the necessary structural changes to reach an optimal level of responsible investments that will not affect human rights and is liable for the damages caused by corporate activity. She's a master in responsible management and sustainable development from University Parapaz in Costa Rica. So I thank Yvette once again for accepting the invitation, and I pass the floor to Yvette Gonzalez.
Obrigada. Thank you for the introduction. Thank you for the invitation. Thank you to my fellow panelists for their presentations. I want to speak a little bit about the Mexican experience in the creation of a national action plan for corporations and human rights. I'm going to share my screen here. And I look forward to giving the talk and also to answering your questions at the end. Yes, we can see your screen.
Un segundo. Denme un momento, por favor. Ahora sí pueden ver mejor, ¿cierto? Entonces,
Sí.
bueno, ya he presentado,
Okay, now we can see better, correct? Okay,
presento mi organización.
so I'm going
Lo
to
que me
introduce my
gustaría es un poco,
organization.
justo
We've
hablar
already
del
said that.
proceso que
Okay.
hubo,
I want to talk about a
anteriormente,
process that
en
happened
2014
in
hasta 2018 para
2014
realizar
to
un programa
2018
nacional de empresas y
to
derechos
have
humanos.
an,
Este programa,
a national program for corporations and human rights. This program,
no me ven, este plan nacional de acción está
this national action
fundado en un
plan
programa nacional de
is
derechos
grounded
humanos en
in a
México,
national program in
cuyas
Mexico,
fechas
whose
de
dates
aplicación fueron
of
en la administración
application were
pública pasada.
in the
Entonces, dentro
past
de este programa
presidency.
nacional había
So
un
within
objetivo que
this
era
national
fortalecer la
program,
protección
there
de los
was
derechos humanos
one
y dentro de
objective
líneas estratégicas que puede tener
to strengthen
este programa se habla
human
de promover
rights,
enfoque de derechos humanos y género en el sector privado,
and
así
the
como en las
main
políticas y
focus
actividades
was to have a
empresariales.
gender and
Entonces,
human rights focus
este
in the
programa
private
nacional
sector. So
permite
this
que de
national
ahí
program
jalemos
allows
un proceso
us to
desde
have a
sociedad civil
process
para
of the
realizar
civil
los planes
society
nacionales de
to
acción o
carry out the
algún
national
instrumento de
action
política
plans or
pública que pudiera
some
funcionar para
public
avanzar la
policy
agenda
tool
en el país.
that could be used to
Lo que
advance the
me
human
gustaría
rights agenda
compartir
in
en
the
línea de
country.
tiempo
So
es
I have
explicar cómo
a
se
brief
crea un
timeline.
grupo de sociedad
So
civil
the civil society group was
para
created
impulsar la agenda, para
to
impulsar los
drive
avances y
forward the
modificaciones
agenda, the
necesarios
advances and changes that would
en
be
México.
necessary in
Y
Mexico.
pues también
And
hay,
also,
se puede decir, una
we can
voluntad
say that there was
política del
a
gobierno
political
de
will
crear
of the
también
government to
un grupo de
create
trabajo
a
multiactor
working group, a
para poder
multi-stakeholder group to
realizar estos trabajos, para poder
do
tener
the
estas
work
discusiones,
and have the discussions.
pero pues nosotros desde sociedad
But
civil vemos que
we from civil
pues hay
society
algunas
see
fallas en el
that there
proceso,
are
aunque es un
some
proceso que
failures in the
empezó
process. It's early days
en
still.
2015
So
a
it
partir
started in
pues, de esta
2015
recomendación
with this
de Naciones Unidas para
recommendation from
realizar
the
los
United
planes,
Nations to
pues ya hay experiencias en este
establish the
momento
plan. So there are
internacionales y también pues
experiments.
guías para hacer todo un proceso de Plan Nacional de Acción o de NAP.
So we
Entonces,
call
hacemos recomendaciones
national action
sobre
plans
este proceso,
NAPs,
pues vemos que
NAPs,
falta
NAP.
transparencia,
So there's a lack of
vemos
transparency.
actores que deben de estar
There
involucrados,
there's
públicos,
the absence of certain
sociales, de
actors,
gobierno,
social
poderes de
actors,
referencias.
public actors, different
Vemos que hace
agencies.
falta una línea de
So
tiempo,
there's
vemos
the
que hace
need
falta
for
una
a
ruta de
timeline
trabajo,
or roadmap
pues no podemos continuar
for the
así,
work. So we cannot continue
hacemos
as we
este
llamado
llamado al gobierno para mejorar un poco el
So
proceso, ¿no?
we called on the
Unos
government to
meses
improve the
después
process. And a
viene
few
un
months
working group de
ago,
trabajo sobre empresas y derechos
the
humanos. Hay
working
una
group
buena relación con el
came to
gobierno,
Mexico,
se
has a good
pide su
relationship with
apoyo
the
para
government,
realizar su
asked
plan
for the
nacional de
government's support
acción. El grupo de trabajo
to
identifica y se
look at the
visita a
National Action
diferentes
Plan. The working group
territorios,
identified different
violaciones de derechos
territories
humanos, abusos
where
contra
there
derechos
were
humanos por la
human
actividad
rights abuses and
empresarial,
violations from business
emite
activities
recomendaciones sobre estos y
and
sobre
issues
el
recommendations
proceso
about this
del
and the
Plan
process
Nacional de Acción,
of the National Action Plan,
lo cual es relevante para poder
which is
seguir
relevant to
empujando
be able
esta
to
política
continue
pública.
driving forward this
El
public
gobierno
policy.
también hace un acuerdo con el
The
Instituto
government
Libanés de Derechos Humanos
makes
para hacer
an
publicaciones, para
agreement
hacer capacitaciones.
with the Human Rights
Mientras esto
Institute that
sucede,
provides
también
training,
la sociedad
makes
civil decide
recommendations, and
que
civil
puede
society
hacer
decides that
un diagnóstico de cómo se están
there's a
implementando
need
los
for a
principios que ya hay en el
diagnosis
país.
of how the
Y el
guiding
gobierno
principles are
hace
being
un
implemented in the
diagnóstico válido
country,
para
and the government accepts this as the diagnosis as a starting point. So the institute in question we found that all the recommendations of the society were not being taken on board. So the institute is called DANES. So then we arrived at the first draft of the National Action Plan, and there were many gaps. So there were recommendations. We're constantly from civil society saying that there's a requirement for a broad consultation to civil society, affected societies, especially indigenous communities, independent unions. So there's a whole process in which so some stakeholders may have been invited one or two moments, but that's not enough. They have to be, everyone has to be present the whole time during the whole process. With participation and decision-making rights. So as for the monitoring process, there were also difficulties from the private sector to accept how many seats could be given over to civil society without recognizing that there is an imbalance of power, a significant imbalance of power. So there were different actors in the work that I show on the screen. And so communities are missing. There are some independent unions, but there are no representatives of people with disabilities, for instance. There's a great lack of diversity vis-a-vis sexuality, various problems. So we created this diagnosis of the baseline for the implementation of the guiding principles about companies and human rights. And so there were comments sent by the public sector and the private sector. So they initially accepted, the government initially accepted the recommendations and then failed to. And so we as civil society started looking at all these omissions by the government in the process and in the content. So we withdrew from the process as civil society because it was not complying with the minimum standards. So I've already commented that there was also a lack of indicators of monitoring. A third part of the international standard was most relevant at that moment was Pillar 3 to talk about justice, reparations. There was nothing in this draft. There was no mention of due diligence by corporations and their supply chains. There was no commitment on the part of human rights respect by corporations. There was no explicit mention of the social and environmental impact evaluations and their publicity and their dissemination, their transparency. So there was a general lack of transparency about all the contents of this draft, and there was no mechanisms for defense of journalists and human rights advocates and whistleblowers. So the prior informed and culturally adequate and good faith to obtain consent was not recognized as a right and was only applied to indigenous peoples, but not peasant communities, for instance. And there, again, no mechanisms of control of public purchases either. So we left the process in 2018 and we continued as observers only. At the end of 2018, the government changed. There's a new president taking office with new ideas, with a discourse that was aligned to these needs that exist in the Mexican context. And so as civil society, we updated our baseline diagnosis. So 3 years later, we updated our baseline. We published our findings with recommendations to advance from the point of view of civil society. We also published an update on the advances that had been made in Mexico and how international recommendations had been implemented. So we saw that there were recommendations for a national action plan, but what we identified in this traffic light is that, involving civil society, there was a little advance with mechanisms of protection. But what is a red light, what did not advance, was the incorporation of the narrative of due diligence, of compulsory due diligence in the public agenda. So this has to be a compulsory mechanism, and the establishment of civil and criminal responsibility for the non-compliance on the part of corporations. So what happens now is that there's an intention. The new government attempts to have a new plan, a new national action plan about companies and human rights, which is also derived from a national human rights program. So we have made major efforts to include concepts of the international agenda on corporations and human rights within the national program. This national program of human rights recognizes that there's a crisis in Mexico, that there is a type of economic development that excludes people from sharing in the national wealth, that there's violence against women, and that there's a need to talk about intersectionality. They say a lot of interesting things. And also this project, this national project, talks about the impunity of the private sector, talks about that corporations have to be accountable, be transparent, especially the ones that receive public resources. Talks about creating criminal types regarding collusion, simulation, talks about the standards have to apply also to suppliers, talks about consultation to indigenous peoples. So this seems very good and would bring about due diligence regulation, reparation for damage caused, but it's not as it seems. Within this National Human Rights Program, there's a priority strategy, which is to drive forward actions focused to ensure human rights of the historically discriminated groups. And those in the government wanted to drive forward the program. There's a lot missing, but some important things that are present is the incorporation of the guiding principles and the guidelines of the OCDE. There's a harmonization of the normative framework. So a public policy instrument to protect human rights could be the National Action Plan in our eyes. Drive forward the creation of due diligence regarding human rights and establishes mechanisms of prevention, monitoring, and integral reparation. This is all of this promotes, establish, drives, but at least it's in the public eye, and so we can push to do something in agreement in line with the national human rights program, which lacks indicators, lacks implementation indications and forms of implementation, but it's something we can use to push forward. So let's look at the national action plan that the government wants to do, which should be based on this national human rights program. We see that it needs to answer some specific challenges for the Mexican context. So there's a lack of coherence between what has been published, what has been said, and what is implemented and complied with. So there's this idea of a national project that talks about having accountability, transparency of corporations, but in practice, it's not like this. This week, there's a presidential decree being published that mentions that government projects are in the public interest and will have fast-tracked permits. So permits will be issued for suppliers without environmental and social impact, without consultation, therefore affecting negatively human rights. So one thing is the speeches and the other is the implementation. And this is similar to what was happening in 2018. There's no participation, in short, effective participation that is still missing of affected persons and communities by business activities. So there's no roadmap, there's no calendar. So these communities do not have the same time frames as the government. So this structural analysis, this adjustment of the normative framework, such as due diligence, these all should be part of an action plan. So if not, it doesn't really make much sense to have a national action plan without compliance, at least with the recommendations that the United Nations makes in terms of process and content. There are many voluntary instruments that exist in the region, have not been implemented. We know in the country we have major free trade agreements with the European Union, with Canada and the United States, and there's no connection between the treaties and a national action plan, for example. Also about business impacts, but especially from extractive activities. So the state takes part in the binding treaty discussions. It's present, but not very proactive. And so for this kind of process, there's a need to bring to the conversation the institutional investors environment. So now we have a regional roadmap after 10 years of the guidelines, the guiding principles, which talks about reparations, due diligence, and so there's a need to know, to understand that there's an inequality of power. There's an imbalance of power, a business lobby behind all of this, and there's the influence of international cooperation when they support the government with different resources to implement this kind of public policies. How am I doing for time? You've gone over already. Can you conclude now?
Well, but there is not, well, we need like a multidisciplinary approach with perspective of gender differentiated impact in this process and in this regulation. And we can also talk about initiatives that are being held for the regulations of due diligence. So I thank you very much for your attention.
Muito obrigada, Ivete. Acredito que também
Thank you, Yvette.
momento de debate, né, vão surgir questionamentos.
During the debate, I believe that there will be
No final sobre essas iniciativas.
more questions, and we can talk more about these initiatives in due diligence that are and we are certainly interested in knowing what's happening in Mexico about that. Now I pass the floor to our last speaker, Professor Eduardo Sanchez. Eduardo Sanchez is a professor in the School of Law of Ribeirão Preto in the program of Latin American Integration from University of São Paulo, senior fellow for Karen and Laura Zicklin Center for Business Ethics Research in the Wharton School, University of Pennsylvania, free professor in criminology from the School of Human Rights in University of São Paulo, doctor in law from University of São Paulo and University of Sevilla, Spain. Received grants from the CNPq, FAPESP, and University of Pennsylvania, United States, specializing in victimology from the University of Sevilla, Spain, 2011. Was substitute professor of criminology and legal medicine in the School of Humanities and UNESP Franca, 2011. So we thank Professor Sanchez, also author of different books, scientific articles, consultant in compliance, criminal law in Brazil and abroad. Thank you, Marina, for the long presentation. None of this reflects my happiness to work with Victoria Laurentiis in this initiative of due diligence in human rights. I'm not a specialist in the area. I'm just a parasite to everything that is developed by Victoria Laurentiis. In this introduction, I should add to here that I'm really grateful for the invitation by Professor Manuela and also, and it was a reason of happiness for me hearing to our colleagues in the panel, Juliette, Victoria, Professor Manuela, and I run the risk of being redundant. As the last to speak, I think that there's a convergence in the way that the previous talks were organized. So I think that what's left for me to contribute is to bring this side of criminology. Added to this democratic deficit that was already mentioned, we have also this checklist promoted by Yvette, the analytics proposed by Juliette, and we have a lack of empirical data. This discussion does not have a complete ballast. We don't know much about human rights violations by companies in Brazil and in the rest of the world. So it's very clear that we have an absence of data. And this debate is also always filled by principles and abstract principles. And when we start to develop measures to protect human rights, of course, that is, measures are models, and hardly we will reach the level of strategic recommendations that will really impact in the reduction of human rights violations, leading to the remediation for the lives of those who have been really victimized, in the social aspects of the lives of those who have victimized. We must be careful to a certain methodological narcissism that dissociates us all. Each one brings the topic to their areas of work, but the most important would be to have one focus regardless of our areas of reference in terms of epistemological or methodological focuses. So the analysis of the impact of companies on society. Without that, we'll hardly be able to create democratic mechanisms to manage the social problems, to recognize from a materiality map the negative impact of corporations on the lives of society, creating mechanisms that can go beyond that, going beyond the common sense, to understand forms that we can use abundant private resources to be minimally shared with the surrounding communities. And here, I am I put most of the criminological speech aside about the abuse of corporate power. So because this speech belongs to 1970s, we have an abundance of prevalence of the companies in the configuration of the global social life. Either we create a speech with scientific basis to guide our actions, or we'll hardly reach any concrete results. In addition to this impact assessment of the corporate impact on the lives of societies, another premise that I use, regardless of this methodological narcissism, is the construction of this case based on the vision of the victim. And then, using the hat of criminologist, we have two important concerns that where we should invest from my point of view. So at first, the analysis of a root cause analysis, to understand what are the causal links, the cause of this socially damaging behavior by corporations. So we must generate a public, global, validated, replicable database that allows us to understand the concrete dynamics of companies within society. And again, this problem of this narcissistic methodology, our impact analysis is very much limited to the description of stakeholders. This doesn't say much about the victimization process, and this does not explain the sources or origins of the socially damaging behavior. Sometimes remediated by juridical processes. So we undergo the juridical analysis. So you have that poor and co-debate on what can be done, what cannot be done based on these normative references. And we know that these normative references are usually captured by corporate interests that we are constantly trying to revert through our actions. In addition to this root cause analysis, I would like also to emphasize that either companies recognize their accountability for human rights violations, or all of our scientific and political debate will not lead to concrete measurements, concrete actions. This is what would allow us to access behaviors. If I understand behaviors, then I will understand the process of victimization. If I understand process of victimization, finally, I can reach the victim. And this allows me to measure the multiple process of victimizations, be them tangible or not. And then I can structure the attribution of responsibility. As we have not followed this process of acknowledgement of attribution of responsibility in Brazil, usually when we make agreements with companies, they are based on the assumption that the corporate responsibility is not recognized. A company does not recognize any responsibility for their employees or any partners, so we reduce the judiciary system to agreements that are favorable to companies, and this does not allow us to implement accountability processes that can remediate the damages made to victims, and does not allow us also to use our criminal our criminal sanction system. This connection between human rights and victims, my head of criminologists brings me to this area of victimology. In the 1980s, victimology was already studying different violations, especially gender violations. So we needed strategies to litigate this process of victimization in courts. The strategy was to connect violations of human rights to process of victimizations. Many years later, many decades later, we have reached this historical moment, and there's a number of explanations for that. We could spend a long time discussing that, but many years later, we can connect this issue also to the corporate world. Of course, that when we take this question for the appreciation of course, the most important is to find the procedure nexus. And then we are again talking about juridical techniques. As we are passionate for cultural anthropology, we leave the walls and the ivory towers of the School of Laws. We look at reality, get passionate for it, we go for ethnography, we get to know the lives of victims. But when we formulate the remediation, we must go back to the state. Do I need to do something for these victims? I go for political anthropology and I want to formulate public policies. When I formulate public policies, again, I have the need for the legislative politics. I must normatize this public policy. So I leave these walls of the School of Laws, but I must go back to them. And what imprison my chains are procedural evidence. How do I produce proof for a process of victimization? And then we have the laws of due diligence. The laws of due diligence come to collect these proofs, to understand these connections between the violation of human rights, the process of victimization, and the forms of attribution of responsibility, but with a specificity, recognizing the sufficient of the state form of formal forms of control. The state can no longer implement this control or surveillance on what happens transnationally speaking with this corporate world. The problem that in legislating on the area of due diligence, we use the same pattern of command and control. Me as a headquarter, I want to know. Me as a headquarter, I do not recognize my responsibility. Me as a headquarter, I do not recognize that it's me that I am myself the subject that takes these damaging practices to the other side of the ocean. The same headquarters that is exploring other market niches. Now I want to know if in the other side of the Atlantic, they are doing what I command them to do. There's a very dangerous risk that it creates the stigma that we are the ones who do things wrongly. It's the stigmatization of those who are producing on the other side of the Atlantic. Then after, it ignores that there's a number of local practices that are much more sustainable than most of the best practices imported from the other side of the Atlantic. And on the third place, and this is most dangerous, this mechanisms of due diligence increase our transaction costs. It's much more expensive to comply with standard operation procedures of multinationals here. I cannot do that. I produce my own family. I produce to my culture, to my local context. I cannot reproduce a very onerous scale production pattern. So I cannot sustain my business. If I cannot sustain my business, I was eliminated as a player. I will be reduced as to a supplier of this multinationals. So we call this context overcompliance, excessive transaction costs. And do we know if our practices are really non-sustainable? Who brings these non-sustainable practices to us? Or is there a complicity between local companies with multinational companies that impose these damaging local practices? Social control is not the same as command and control. Social control is a convergence of controls. We need to acknowledgement of responsibility, constant attribution of a responsibility. The local ordinance is not enough to attribute responsibility, is not enough to inspect violations of human rights. For us to open to other forms of control, for informal social controls, instead of insisting on formal social control coming from abroad that have been increasing my transaction costs and stigmatizing what's happening in the country, eliminating smaller players that sometimes are much more sustainable than large players. Large players are the ones who bring predatory practices. So I stop training my local environment. Due diligence should come to allow capacity building measures for the local environments, less principles, more concrete actions oriented to an objective goal on what is sustainable, how to revert non-sustainability, and who in fact is bringing this socially damaging behavior that creates victims. So this is what I had to bring to, as my contribution to this debate. Thank you for the opportunity.
Obrigada, professor Eduardo.
Thank you, Professor Saad. So now we are going to start our debate and the questions. I see that Professor Manuela has raised her hand. I also have many questions that were sent along your explanations and the content that you brought to us. We also have some questions in the chat box. So I invite you to raise your hands and ask your questions orally, or you can send your questions through our chat box. Manuela, do you want to start? I have a lot of difficulty to be objective and asking the questions in written. So orally, I think I go better. But I will direct my question to all of you. I really like the panel. It brought like interesting reflections and also convergences. We are happy that we see that we are close to each other, close to other actors that research on the same topic. And I thought that it was very interesting to hear from Professor Eduardo Sanchez talking of our territory as if we were the ones to blame for this damaging conducts, as if it has everything to do with the speech of neo-colonialism, new imperialism, and it has to do with the role of the company. Structurally speaking, we have been talking about the race to the bottom for a while now, me and Juliette, in the negotiation of the binding treaty. The dynamic of the corporate participation of companies in terms of the reduction of human rights protective standards. This is structural to make this a the global South territory as a place for human rights violations. And what do I mean by that? We see that this is reproduced under the approval of the standards supported by the UN, the guiding principles, the logics of social corporate responsibility that put the company as if it were neutral, competent, rational player. And in the global south as the field of barbarism, where they arrive and they are forced to violate human rights. And in the UN, we see a contradiction, not brought by us necessarily, but the states that represent the company's headquarters. They usually say, the problem is at the national level. The problem is in the global south. They are the ones that should improve their conduct. So we don't need the international treaty. We need to take best practices to the global south in order not to violate human rights there, as if it was not the responsibility of the companies. So that's what I want to ask, leading to this discussion. Up to what point should we gain in this space to leverage these national action plans still within a language of the guiding principles or a language that makes reference to self-regulation? Does this help us to keep this narrative, or shouldn't we fight for rupturing this this field? In Brazil, we are making the effort to recognize the need of national laws, but we are calling this a framework legislation. We don't want to use the languages of the law of due diligence or the national action plan to create this effort to overcome these paradigms. So this is the question. Thank you very much.
The question from Professor Manuela has been making us reflect for a long time. It's an important one. It'd be important to hear our speakers about that. So what is the role of these due diligence laws and national action plans? Have they been playing vis-a-vis the treaty, the binding treaty that is under discussion? I'd like to hear from our guests about that. Juliette has already raised her hand. You can begin. And then to whoever else wants to comment. Thank you for the presentations, very interesting ones. I'm going to answer, and there are some written questions as well that I can comment about the European directive. Firstly, to answer Manuela from the French and the European point of view. So in France, there was almost at the same time the whole debate about adopting the French law about the duty of diligence, and in parallel began the National Action Plan of France. So we, as Friends of the Earth France, we are not involved in the National Action Plan discussion. We have a very critical view, but other organizations have become involved here in France. The plan in France doesn't have much to say. The only thing that we can say is that the Consultative Commission about Human Rights is the body that have to evaluate the National Action Plan. So we use that committee to evaluate implementation of the French law. So to advocate in favor of the French law, we instrumentalize the guiding principles using one line that says that to take action, states have to legislate. So they can't escape that. The guiding principles talk about binding legislation. Now, to go over more to the European debate, there's a big problem in Europe. There's a confusion about due diligence. Everybody uses it, but they use it with different meaning. So the companies want to have a very narrow view of due diligence. The European Commission or the European Parliament has a different view, different definition, and social organizations, we as the French coalition try to explain to the European organizations that we don't want a due diligence law. We didn't win that battle of terminology. Many organizations in Europe talk about due diligence, including the mechanisms of access to justice and accountability, legal accountability. which are not included. So this created confusion in the debate, and we, as Friends of the Earth France, but as the French coalition, try to show what the part of the French law that is based on due diligence is the weakest part, and the ones that we're fighting to improve. So this creates a lot of confusion, and that has spilled over to the European directive discussions, but also at the national level in different countries. We see that some organizations of society say we want a due diligence law, and others, and seem better, say we want a law that regulates corporations and putting the focus on access to justice above all. Regarding the draft European directive, there's not much to say because the text has not been published yet. So it was supposedly going to be published in October. Now we're expecting it for December. Maybe it'll be, like a Christmas present on the 24th of December or something. So what we have right now is a report from the European Parliament saying what the Parliament want to see in the legislation, in the directive, and we have statements from the Commission, especially the Commissioner on Justice, about what should be present in the directive. It's not called a directive on due diligence, but it has a strong due diligence component, but other points as well of mechanisms of access to justice. All this is under debate right now. We consider their many points are weaker than the French law, but actually what we would like is to go beyond the French law and correct the weaknesses of the French legislation. So the debate is wide open. Of course, the business lobbies want there not to be any mechanism of judicial responsibility, for there to be no coverage of the whole supply chain, etc., etc. There'll be a report about the lobbying coming out soon. And regarding the UN treaty, the risk is doubled, that the European Union will use the process. Oh, we're too busy at the European level. We cannot be involved at the UN treaty. A new excuse to not devote itself to the UN process. And the other risk is that we have a weak European directive, and then the European Union uses this weak text as the base for its position at the UN treaty. So then the European institutions published a small briefing to talk about the two processes, how they connect, to make sure that the European Union can take inspiration from the UN treaty, which, in spite of its weaknesses, is much broader. It has more coverage. So once again, we don't have a text, and the battle is only just beginning at the European level. Thank you, Juliette. Any more comments on Manuela's question? I think people can comment any other question they would like. I was going to say that maybe Manuela's question can be complementary to Renata's question directed at Victoria. So the political moment is favorable to a national action plan in Brazil. How do you look upon the process of the international treaty at present? And maybe you can answer that question with together with Manuela's points. Firstly, thank you for the question, Renata. I think The first thing to say some things about what Professor Manuela said, the idea of taking to the global south the best practices as if they didn't have a role. It's unreal to think that corporations, these major business organizations, they're not part of the movement. On the contrary, they have an essential problem in the construction of this agenda to neutralize or annul the participation of these actors is to ignore an essential partner element. In other words, we are discussing how to translate. So to talk about human rights is a field of dispute. How I bring this as obligations, positive or negative, and I cease to involve the target of the obligations. So in this process, it's a reflection for our national plan formulation. Any level of effectiveness that we intend to have depends necessarily on rethinking how to bring the state regulation closer to the corporations. Self-regulation is not enough. It's very problematic. We all know that. So the last cases, the recent cases, Samarco and Vale, Brumadinho and Mariana tragedies, a lot of the information that was disseminated there came from the corporations. So self-regulation is not the way forward. There has to be a state participation, but the national plan represents a step, a compromise. At my view, it will only happen if we changed this reasoning of thinking actually in mechanisms to incentivize the change of the business culture, to think also about this command and control model only. We're going to have a legislation at the end or an agenda that will be great, but ineffective. Again, on the other hand, the exit is not to all countries need to create or develop their own due diligence laws. That would cause a legal problem as well, a transnational problem, particularly when we're talking about organizations that are active in more than one jurisdiction. So this process necessarily has to be collaborative. I cannot design a national action plan without any communication with the other ones. In one way or another affect us. Regarding the incentives, we have to think about game theory, incentives and disincentives to the behavior of corporations that is socially and environmentally harmful. So about the political moment, is it favorable to a Brazilian national plan? In terms of Brazil, I think it's very hard to have an adequate political moment. If we start off from that premise, there is never an ideal moment. Brazil is delayed in many stages. The last participation of the country at COP26 was shameful. We had the worst deforestation rate in 15 years, an increase in 20% and 22% in relation to last year. We look at the serious human rights violations to be addressed. After 2020, there has been an increase in hunger in Brazil that was impacted by the pandemic, but not only. So about half the Brazilian population has some level of food insecurity. 19 million are actually going hungry. And this is data of the last year and this year. In terms of sustainability, the worst cases of deforestation, the disassembly of the social environmental protection mechanisms, and suffering what we call the regulatory rollback, which is an American concept. So the process we're living through in Brazil our setting, with all of this with all of this uncertainty, the worsening of the political, economic, financial, health, social, environmental crisis demands immediately that we build the agenda, because it's not something that happens overnight. It's slow. If we wait for the right moment, we will never begin. Particularly talking about Brazil and the problems we have to deal with, as well as having to deal with corporate capture. I think developing an actual action plan in Brazil should be conditioned to the political moment or the government happens to be in office. This is something that has to develop much in spite of the political setting. And to talk about the negotiation of the treaty, my understanding is that there is a need to have a binding treaty. The discussion of an international treaty is very important. A normative framework is important at international level that can be replicated in the national legal order. It's slow. A treaty cannot be approved quickly. There's a lot of lobbying happening. If we look at the first drafts and the current drafts, we see the influence of corporate power in weakening the text and the demands. But I think that it's important to stress that it would be unreal to think that a treaty by itself would be able to change the setting we are living through today of intense violations of human rights by corporations. So we have to have mobilization of civil society, especially because of corporate capture of the process. But I don't think that it is likely to think that through a treaty, we are going to bring about a movement, a strong movement, strong enough, which is anti-hegemonic, with a different process of globalization. For example, we had an event recently with a professor that has a direct participation in the negotiations of the treaty, and he said something that I agree with. Is we need to think of a new model of globalization that starts off from the need of thinking how our development cycle works. What's the role of corporations? What is their role in promoting rights? How can we rethink this logic? And then rethinking the model, rethinking its basis, then it has to be rebuilt. So the treaty would be a first step by itself. It's not, it wouldn't solve the problems because it depends on addressing urgent ideas. If we look at the international setting, corporations today have no international legal personality. They're not part of direct negotiations as legal entities, legally constituted entities. So there are other problems to be addressed, and there is a vulnerability in mechanisms of international accountability with a view to sanctions, for example, on business organizations. That also has to be addressed in parallel with all the questions that are being discussed in the treaty.
Thank you, Victoria. And piggybacking on what Victoria said about the corporate capture, and I want to ask Yvette a question. We have seen when we were talking about the Mexican process, and we can use this as an example. We saw a little bit of this corporate capturing the example, the absence of the civil society voices, and only through the participation of civil society, we will be able to see changes, to provoke any types of, to lead to a more protective legislation and call And what called my attention, and correct me if I'm wrong, in a certain moment, I think you have left the process. In these spaces, if this is a non-democratic process, is this a process of corporate capture? Up to what point should we remain in the space of a dispute, trying to include the agenda of human rights protection? So I want to hear you about that, and also listen to the comment of Professor Saad. He talked about victimization. So the use of a human rights violation is difficult to use. They are trying to escape from this responsibility. The term is also always adverse impacts, with the goal of not acknowledging that there's a victim on the other side, that there was a violation of human rights.
Muchas gracias, Marina, por la pregunta. Efectivamente, fue
Thank you, Marina, for the question. It was an analysis that took us a long time as a civil society coalition to make the decision to establish this process, exactly because it was not inclusive, not democratic, not participative. We are an organization that most of us monitor communities that have been affected by corporate processes in their human rights, in their environment. And we cannot be part of a process that will not protect their rights, that will not repair the damages. At this point, when we made this decision, I was asking who was funding this process, the Spanish government, if we would rather have some wrongdoing or no process at all. So for us, this was a very strong question. We don't want something that doesn't work. So why would we dedicate our time, our efforts, and why would we build a hope for the affected groups if we are not reaching nowhere? If we are going to something that is not permanent, with different perspectives, with different projects of a nation, different corporate plans and government plans that won't work. So we run the risk now of falling to the same trap if they do not comply with these minimum requirements. We have to think up to what point we want to go, if we want to continue in this process, if we want to drive more strongly for more appropriate legislations for this context of corporate capture of the state. Corruption is also very strong in Mexico. So what is this option? It's important to think of this interconnection that there is in Latin America, how these plans are arising, emerging, what are the failures and opportunities that have been found. There are agreements that are there at the regional level. It's also very important to remember that rights are not negotiable. This is not something that the corporate sector will cover through tax incentives. It is not negotiable. They must comply with them. It's their obligation. They must be respected. Talking about extraterritorial obligations, for us, it's really important with this free trade agreements that Mexico has signed to. There is a complete lack of transparency in the processes. We don't know how human rights are being treated in these areas. And for sure, we need juridically binding instruments under the international law. None of these instruments will be the panacea, will be the silver bullet, but they will help us to advance a little bit faster in this agenda, because for many years we have been struggling. And of course, that there are those who wish to lower our ambitions, that they want to create a conventional framework from the European Union that will not reach the maximum level that we can achieve. And this can be useful, of course, in the ROI, return on investment, and also for the company's sustainability. So if we see ourselves again in this situation where there's no interconnection between the instruments to which Mexico has committed, the international conventions to which Mexico is a signatory country, and other ILO conventions and other commitments to stand up process in parallel. So I hope I have answered.
Gracias.
Thank you.
Alguém mais? Professor Eduardo?
Anyone else?
Professor Eduardo, sim.
Professor Eduardo. Once again, I want to thank you the opportunity to participate in this debate. And I think that what Marina is saying is absolutely right. And I cannot say that the treaty is not important, of course. It's auspicious, so as to speak, and we must, of course, and I need to be coherent, but the issue is that we learn very little. It has been more than 1 decade that we have had the guiding principles with a very low performance level. At what moment will we conclude that guiding principles don't have a wonderful performance, and when should we correct our course? There's a number of techniques to neutralize these treaties. The idea of removing human rights violations is exactly an attempt to replace that for adverse effects, is of course trying to escape from responsibility, but it's our responsibility to identify these negative impacts, to identify empirically the dimensions of socially damaging behaviors. How should we create damages, not only tangible damages, but also intangibles? In more recent cases, we see a loss of a life purpose, depressive symptoms in the survivors, and a situation of constant humiliation by the lack of a fair process. This is also a process of a socially damaging process, and also the judicialization of conflicts. The different players, you see the process of, there are people that are responsible for conducting these conflicts. They have good intentions, they are extremely qualified, but they are not able to deal with the huge dimensions of these conflicts. In addition to these neutralization techniques, we have the fact that we don't have an enforcement structure. We refuse to understand the dynamics of social control, even from the point of view of a universal jurisdiction. Who's going to put that into practice? Are we going to put that into practice in the same like we did in the international courts, in a very selective characters, selecting some situations of vulnerability in Africa, very far away from the southeast of Asia, very far from the Colombian case. So a universal legislation could reproduce the same selectiveness at the international level. And this, for corporate purposes, will lead to the same place: anti-competitiveness principles, elimination of players. So we should understand not only the negative impact of companies, but the negative impacts of an international legislation could be extremely important. As we cannot have a consistency in these answers, the private sector, they come and they put their dominance into practice. The socially economic the ESGs, the environmentally responsible negotiation rights, are all in the field of corporate regulation. Today, the private sector is the one that says if an operation is is environmentally responsible or not. So we lost this capacity. The difficulty to evolve in our strategies of formal social controls has relegated us to the role of the side players. So how many years will take us to identify the fraud in a fraudulent report, for example, or in the issuance of green bonds that in fact do not have any ballast? The ones that say if environmental report is sustainable or not are the investors. So we must evolve and in these practices. We have still a lot of room for development of these practices. Thank you. And now we going to the end. This is a panel that invited us to reflect, and specifically we see this in terms of the development of self-monitoring norms, voluntary standards, but at the same time, what Yvette said, the corporate capture of these processes, the absence of the voices of civil society organizations, this process of mapping out the damages and creating reports is done by these organizations of civil society. They're extremely important, but that are not announced, not disseminated, because these are excluded groups. So we have very practical data, and they are oftentimes excluded from the process. So we end up bringing, we need very much this reflection. So this was the role of this panel, to analyze the role of this due diligence laws, if this operate as a normative checks and balances. And I think that our guest speakers brought us a lot of information that will help us to reflect on that based on different points of view, and also from different regions, what's happening in Europe, what's happening in Latin America, Mexico, Brazil. So I want to thank you very much for accepting our invitation, to dedicating your morning to this panel. And also, we want to thank all the participants and to invite you to participate in the afternoon panel at 2 p.m. on the need of human rights and businesses framework legislation that will exactly contribute to add to this debate that we had in the morning. After all of this discussion, what would be this framework legislation in Brazil in this scenario? So we thank you once again for your presence.